On the side affirmative, we say privacy is extremely difficult to specifically ascertain the boundaries of. We on affirmative will facilitate the necessary public behavior, such as whistleblowing, while also being able to protect the dignity of these individuals. 2 points of setup on where this debate occurs. Firstly, we would allow for the defense of criminal charges and only criminal charges, i.e. the breaching of privacy legislation, to be justified. This could look like anything. I'll signpost that in my arguments. Secondly, when these individuals are charged to be in breach of these, they can plead the defense of public interest. What burden do they need to prove? They need to prove on the balance of probabilities that the public interest that they have garnered outweighs the privacy violation. And notably, this is similar to the Evidence Act of pre-existing legislation and can function in one of two ways. Firstly, partial, insofar as you can sufficiently prove that there is a reduced sentence insofar as these individuals will still be charged. The example is a journalist may breach too much personal privacy while pursuing the interest of public interest. Secondly, in terms of full defense, so if individuals can sufficiently prove a large enough of public interest to be proven, i.e. whistleblowers of significant corruption in government, for example, the necessary breach of some privacy will be traded off to be sufficient to acquit them from this crime. Two arguments then from side affirmative. Firstly, of why this is necessarily the best construction and conception to the right of privacy. Secondly, on why courts are the best actor for this. The characterization of the first argument is to just simply explain to you the degree of privacy in the status quo, while sufficiently necessary in some instances, the bounds and the delineation of when it is applicable is particularly murky and unclear. What does this look like? In the status quo, we say that it is frequently and consistently a trade-off for alternative considerations and rights. E.g. surveillance obviously is a breach of privacy, but necessarily we agree that CCTV is probably best for keeping public areas safe. Another example is the metadata retention of individuals when they access the convenience of online services. We can see that these breaches of metadata and privacy are sufficient and justified insofar as it prevents the harms of terrorism, for example. And the impact of this is to explain to you that it is particularly difficult on side negative to mandate legislation that doesn't infringe on the control of activities, which is necessary and crucial for social order and for keeping certain individuals, certain stakeholders accountable. On side affirmative, what we give to you is that these courts, on a case-by-case basis, i.e. literally the info slide, I guess, or the motion, will give tailored, detailed, and informed decisions on the outcomes of these criminal cases. Now let's explain what this model actually looks like, how it functions in courts, and why necessarily they're the best actors. Firstly, on judges, we explain that these individuals are often experienced to make the trade-offs and do so very, very often in the status quo. For example, like I said, the Evidence Act, they're able to weigh off the probative value versus the prejudicial value. That is, they're able to value which evidence is significantly valuable versus the risk of that evidence being misleading for juries. Secondly, we point to you that these juries in the status quo are able to make these trade-offs insofar as they are able to reasonably weigh these things up. But also notably, the jury that is probably picked for these cases are also literally definitionally the average reasonable person. So insofar as that is the case, they are probably able to do this trade-off anyways, insofar as they do this in the status quo. Thirdly, we explain to you that substantial thought and consideration is often put into these things insofar as the thought and consideration of these things are probably done to a sufficiently efficacious value. Why is this the case? Because they often are done in the conscious and the context of having a precedence. Insofar as this is often precedent setting, they probably note that and probably weigh that quite highly. But secondly, we note and trust them in a variety of other areas. Insofar as in civil and criminal cases, we trust the juries and judges to make very significant decisions on the lives of individuals, on the lives of corporations, on the lives of very many people. And fourthly, we just explained to you that defense and prosecution in the status quo and on the outside would have the ability to actually explain to you why necessarily they are actually outweighing, i.e. the public good of these individuals or the breach of privacy. And that is why necessarily the impact of this is there's probably and likely to be a sufficient and nuanced and relatively sophisticated understanding of the boundaries of these outcomes. And that is to say, this is sufficiently important insofar as negative has either two, conceptions of the outcome in the status quo. What does this look like? Firstly, we would say that it is necessarily narrow in terms of the constrictive value of these laws, insofar as it actively limits what you can protect and what you can't protect, or is too broad insofar as they are too expansive, too general, and prevent a series of necessary activities and pragmatic protections which exist in the status quo. A few and multiple benefits on the outside of the house for why necessarily this is significantly important, why necessarily this is alone enough to win us the debate. Firstly, because it is often particularly useful for social activities and to govern and form as a or function as a accountability mechanism for individuals or for governments and things like that. Insofar as you can use whistleblowing mechanisms in order to check corruption, to check political malfeasance. We will point to examples like Julian Assange on the outside of the house would likely be acquitted, things like that. The second thing to explain in terms of benefits is to explain whistleblowers on the outside of the house are far more likely to come forward. They are far more likely to be able to provide more forms of evidence. We will point to examples of Edward Snowden. And the reason this is particularly true is insofar as they're able to plead this defense, they're obviously much more likely to be acquitted. And given that is the case, obviously that is a positive incentive and an upward structural push for these individuals to be far more likely to come out. The third reason for why this is particularly useful and particularly good is just to explain that those individuals who are pressured into unfair NDAs are much more likely to be able to break those NDAs. Obviously and notably, NDAs function as a privacy mechanism in the status quo. We would explain that being able to breach that in the interest of the public good would be a sufficient defense under our side. And this means examples such as the Weinstein cover-up of the #MeToo movement and things like that, obviously far more pervasive on the outside of the house insofar as these individuals, once again, far more likely to come forward, far more likely to be substantively changing society for the better, and also to be acquitted and not breaking any laws. That's probably an individual benefit to these people anyways. And the fourth and final thing to explain under this is to just explain to you that there are a set of examples which exist in the status quo where this is applicable, like literally right now. We will point to like pre-existing implementation, such as the Project Warhead case of the Queensland Police, of the Lena Gang case, where they were like claiming game meat and selling that, and then a journalist snuck in and revealed that they were, selling possum meat. And while that example might be marginally arbitrary, we would say that under those circumstances and those examples, even if they are technically trespassing, technically infringing on the principles of privacy, we would note obviously that is a broader social impact that accrues under our side insofar as these individuals can actually expose that information, insofar as these individuals necessarily are able to combat that, things like that. And the final thing I'm going to do is just do a little bit of preemptive work in regards to their attacks, probably in regards to corporations and government abuse of these laws. We just point firstly to all of the mechanisms we explained to you in the status quo where these laws and these judicial structures can do this anyways. And secondly, we'll just note to the precedents where these laws of privacy already actively infringed by the metadata of social media companies, by these governments infringing on our privacy in our day-to-day lives, like dictating what we can do or we can't do. And what we need from side negative for them to actually overcome this burden is proof necessarily in these individual instances of privacy why that privacy is necessary and why that privacy being breached does not overcome the balance of probability of the literal definition of these social goods being particularly useful, particularly impactful, particularly just good for the general society that we live in. For those reasons, extremely proud to affirm.
Determinant of who is problematic, criminal, and skeptical should not be put into the hands of public individual vigilantes. A side affirmative mischaracterizes what exactly will be used during the process and who are the likely stakeholders that are going to bring them into civil causes. We believe that whether or not the estimated public interests are achieved on side affirmative, we are saying that the irreversible harms incurred during the process without procedural justice and due process is already having detrimental privacy violations on these estimated individuals. I'm going to do 4 things in my speech. Firstly, some clarification on the setup. Secondarily, I'm going to talk about how this is going to be misused in the criminal justice system. And third of all, I'm going to talk about what exactly does it feel like to your policy violation privacy being violated. And finally, I'm going to engage in a best case scenario to say even though they have increased public interest, this kind of decreased privacy protection is significantly harmful for those individuals. Starting with this clarification on setup. So, what does privacy legislation violation exactly look like? I think side affirmative affirmative is very soft and vague during these circumstances. I'm gonna give you 5 specific categorizations of what exactly is happening in the status quo. For example, there are likely to be civil courses where like a coder who is skeptical of a company who is like violating public interest, they're going to hack into their computer or cell phone, even if they get the information that is actually detrimental to public interest. But right now, they're granted under the protection of policy violation. And secondarily, when police are determining their investigation process, when they're facing obstacles, they're just directly to go without the privacy protection. They're more likely to violate the privacy and to directly access the database. They shouldn't have done at the very first place. And the third scenario is that media companies are also more likely to leak individuals' information where they're failing to meet public narrative and when they're deeming to be like harmful and toxic to the society as in favor of public interest. And fourth of all, they're also likely to be journalists who will publish celebrities and politicians' private life and private information. For example, they feel like the chat history of a certain politician is probably pedophile or sexist, even though it's not generally deemed as like public interest, but right now they have this kind of claim in order to bring into the court and to defend themselves. And fifthly, we're saying it's more likely to be in the civil court where you have like a private disputes and private cases. So what does public interest exactly look like? We're seeing that the fundamental problem why this could never be a defense is that public interest is such a vague and arbitrary term that you can personally fabricate it. 2 problems with this. Firstly, we're saying public interest is very likely to be dominated and decided by majority tyranny. And second of all, it excludes the minority ethnic group, and third of all, it's likely to fall into the mob mentality by media propaganda. Why is it problematic? Because A, right now you can claim anything to be in public interest as long as it is politically correct. You can use it as a defense to violate the opposing party's privacy. And secondarily, we're saying you yourself can like make up an excuse to say because this is politically correct, because it's generally accepted as a social norm, therefore this is in the public interest. The scenario of what they're engaging is basically talking about how public interest like can give us more credential information. However, we are saying in the status quo, even without the policy, we can actually already get the desired information they want. So scenario number 1, police, they can get warrant. Scenario number 2, IPN and bureaucrats already have authorization to investigate in very problematic national threat issues. And third of all, engaging in their best case scenario of whistleblowers, we basically have 2 responses. First of all, whistleblowers currently have like journalism protection laws, and they have permission and grants and access in the status quo, which leaves them untouched. And secondarily, like we say, even under this policy, they're still unlikely to win the lawsuit against governments and political officials. Why? Because A, the prosecution you're facing, aka the government, has huge capital and financial capacity, and they have more media control, comparatively speaking, over an individualistic journalist. So even though you bring this to court, you're still likely to lose the lawsuit. So it doesn't have a nuanced benefit on side proposition. And secondarily, we say the more likely situation is that before you bring this into the civil court, you're likely already to be cited. So we're seeing the biggest benefits of side affirmative will never be brought into the court and will never be applied into reality. At the very first page, we directly mitigate their entire case. Now, move on to 2 substantial materials from side negative. Firstly, how is it going to be misused and how is going to increase arbitrary vigilantism of vigilante justice. So firstly, we say this actually encourages lazy policing from the police. Why? Because first of all, police right now have an alternative to directly violate the privacy right, directly access their personal information and personal database as long as they say they're properly strides and socially damaging to the society. So we're saying without the protection of due process and procedural justice, your privacy is at the stake of being violated at various adverse circumstances as long as police make up the excuse of so-called public interest. And secondarily, we're saying you're encouraging more individual vigilante justice. As I've already proven to you why this is unlikely to be used in a case of whistleblowers. It's more likely to be a case of like random coders hack into computers or like some journalism, spreading personal information like the sex life of a certain politicians because they can claim this is in the favor of public interest. Public has the obligation and public has the right to know exactly what is happening. Why is it harmful? Threefold. Firstly, it is very random or arbitrary and it poses every individual at the stake of privacy being violated. The reason why we have privacy violation at the very first place is that we do not want to face the constant threat and constant anxiety of what if my sex life is going to be exposed to the society like tomorrow. And secondarily, we're just saying this is actually more harmful to marginal group of society or lower socioeconomic class because they're more likely to be deemed as problematic. So we're saying this is actually shifting how the criminal justice system are designing sentences. preemptive form of justice. This is principally unjustified because you feel like someone is skeptical and you not have the primary ground to just directly violate their privacy in order to investigate them without certain proof at the very first place. We're saying this reverse shift and reverse burden of proof within the criminal justice system is something we don't want to see. Finally, move on to what exactly are the problems without privacy protection. And I also want to engage in their best case scenario. Even though at their best case scenario, they can prove that there is a marginal increase of public interest, just nuancely and significantly exclusive because of this policy, we still feel like that the privacy violations and the harms to incur to individuals should not allow this policy change. Why? First of all, they're saying privacy can be sacrificed because privacy is something way and privacy is not that important. It's the reason that they never directly engage and try to imagine what exactly does it feel like for the privacy to be violated. We're saying no matter or not whether you win the trial, today the difference is that those kind of privacy and the information are going to be leaked into the public and they're going to be on the trial. They're going to be like witnessed and cross-examined for several times. It means that the certain piece of information that you desperately want to protect it, regardless what kind of purposes, are going to be exposed to the public without any sort of justifiable means of protection. That means that something that is very credential to you and very important to you are going to receive huge public backlash, criticism, and judgments from your everyday life. We're seeing this in current health day by day is actually detrimental to the mental health and the well-being for a certain individual, and we see there is no reason to violate this kind of things. And secondarily, regarding to like hacking for corporations, it's just very simple that you already leave their credential information, which is probably strategically useful for them or company strategy. And third of all, it's also likely when journalists are leaking information that they believe is in the public interest, they're also likely to be military information or credential information within the government, which are not supposed to be exposed to the public at the very first place, and they are ought to be retributed throughout this entire process. So for all these reasons above, never powder to oppose.
I have the right as an individual to get up now, drink a giant cup of vodka, and then kind of do whatever the fuck I want with my life. I am not, however, allowed to step into a car and continue driving the road where my capacity to do harm onto other people in front of their own right for safety is particularly likely to be threatened. The problem with this negative team is they never identify that everyone has rights, but also that necessarily we trade off rights all the time. Because necessarily every single right exists in tension with others. Your right to safety is obviously mitigated by, for example, people's right to their own personal freedoms, whether that be speech, action, etc. And it is the job of a legal system to determine the intersections of those rights and identify which ones we all prioritize. They are never able to explain why public interest was necessarily always going to be something that was more important than an individual's privacy, at the point where individual's privacy and that right to that privacy was still a consideration in our system. It was not as if the public interest was king. You had to prove things in a balance of probabilities. That was why Affirmative take this debate. 3 questions in this speech then. Firstly, I'm going to evaluate how this impacts behaviors of individuals and kind of the scope of this motion. Secondly, on how this is applied within the justice system itself. And finally, if I have time, I'll deal with their privacy stuff. Firstly, they have a couple of claims in terms of where this debate takes place. The first thing I want to note is in their push on civil cases, we've simply modeled this out. We've given no reasoning to suggest why this isn't fair in the debate, so this seems pretty reasonable. And also just like clearly the highest impact in the debate, right? This is the point where you're violating laws that have capacity to send you into prison. That would seem particularly important, and it's where this defense is quite clearly the most necessary in instances where side Affirmative would suggest it is justified. Let's look at the examples that they give and suggest why these are likely to be flawed. First thing they explain is, police will go in without warrants and can violate privacy, whereas they should just be able to get warrants. First of all, and I think the most important thing to note in this debate, right, the public interest is not something that is kind of vague and amorphous that they want to identify, given it is being weighed up against something very tangible, which is individuals' right to privacy. And for all of the reasons that they explain, individuals and society in general values your privacy quite highly. That is to say, people do not like being having the police storm into your home without a warrant and go and seize evidence and take that away when it's done lawfully, which suggests that for the types of instances they want to talk about like this, there's an extraordinarily high burden on police to prove exactly why that is in public interest. Such to the extent that the chance of an individual officer doing that at the point where you could actually hold them criminally accountable was never going to take that risk because of the sheer individual damage that would do to their own career and the likelihood that would do of having them thrown in prison. This is of course assuming that groups like police actually can be meaningfully charged, which I would argue they probably can't in status quo, which suggests that even on their side, this action and behavior can and does in fact happen fairly regularly, which would suggest that individuals in certain situations would not take the risk because privacy is something people value for the reasons they explained. That means that this does have to be proven, and individuals are unlikely to take that risk for just the reasons of, oh, it's going to make our lives easier. Second reason they give is, social media companies leaking private information so such people get doxxed. I think this also is true, because I think to the extent they're going to claim individual safety is being violated by the release of this information, that is probably a justification that the courts would be really good at weighing up. Because of that, courts have an active incentive to promote things like order in society, and to the point, for example, a social media company is pressured into leaking information about where someone lives so people can go to their house and attack them and root it. I think that is a sufficient reason to explain it is maybe not in the public interest unless there was an extraordinarily high justification for that to be the case, because the individual's right to privacy is simply far, far greater at the point privacy includes your own personal safety. So I think their most uncharitable claims in this debate simply fall out. For that reason then, let's turn to the question this actually hinges on, which is the public interest itself, how this is applied in courts. They have a few responses to our claim. The first one is to explain that the public interest is a poor metric for justifying this. They have two claims here. Firstly, to say it's arbitrary, and secondly, it's just as criminal justice free preemptive. I would note that people make decisions about committing crimes all the time. That is to say, obviously not all murders are spontaneous. People do a weigh up in their minds about whether or not they are able to likely to do things like get away with it. Obviously, in many instances, that is not ideal because murder is a not socially utile outcome. However, obviously at the point in which an individual makes a weighed up decision as to whether or not this is likely to be something that they are able to get away with, but that produces positive outcomes, that would suggest this is a seemingly fine and fairly reasonable thing to do, to the extent that criminal justice obviously applies at the point the action occurs. Yes, you can plan your way around it, you can try and plan your way to get out of murder, but that doesn't matter, right? You still assess the evidence in court, the comparative value that it has on society, etc. So this seems particularly unuseful. In regards to the public interest being arbitrary, I simply think that that isn't true. Like, obviously the public is a pretty broad actor here. And so, the extent to which certain individuals that might be beneficial for is unlikely the case for many people. And note that the group who's actually evaluating what the public interest is, right? It's the jury. Juries in general are quite socially diverse. That is to say, there are a huge number and different types of people who often end up on juries. Prosecutors obviously have the ability to strike out and moderate those juries so they can be particularly balanced. I think that would suggest that juries are actually a very good actor for advocating the public interest. Because unlike what this team claims, it's unlikely to get a bunch of people who are just like chronically online killed on Twitter who want to go and harass a bunch of people and demand social media companies to release like information about where people live or their sex tapes. Obviously that is not particularly useful to a social interest. It seems incredibly unlikely that this type of public interest that they describe is likely to occur. It's far more likely to be the kind of reasonable one that we propose on Affirmative, particularly in the instances that most talked about. Because given that an individual is obviously far weaker in comparison to large institutions, courts are actually likely to preference right to privacy when it comes to individuals in a way that in the types of cases we talk about, like for example whistleblowing, they're not likely to privatize that right to privacy because of the fact that a corporation has far higher capacity to influence harm. And so at the point where they are doing harm, any exposure of that harm means that it is in a far higher incentive and far higher interest of the public than other types of crimes that they would likely suggest. The next claim they make is that, this promotes a kind of vigilante justice. I think this is simply an insane claim for the very simple reason that people do not want to be thrown in prison. I think an individual, particularly one who does not have a particularly strong incentive early to engage in this behavior, in a way, for example, a journalist does, because they have things like sources that usually go them on to leads to suspect this is something that might be, and particularly ones who don't have the backing to be confident in their ability to do this successfully, are extraordinarily unlikely to engage in this kind of behavior. And I know the exact way that people do it in a way that is definitively in the public interest is extraordinarily unclear, and it probably is more likely to people like journalists we talk about, etc. Because also, for the reasons they identify these groups being really powerful, journalists and the organizations they work for are likely to also have lots of capital to be able to hire things like lawyers, etc., and to provide reasonable defenses for them. The next claim they make on this is just to say, it doesn't actually matter, because at the end of the day, the prosecution is still going to win in our best cases because it's groups like the government. I think this is simply untrue for two reasons. The first is to say that yes, you can have lots of money in the prosecution, but obviously, and particularly when it's in the case of public interest and in our worst instances, juries are obviously going to be very likely to value the information of the defendant more. That is to say that obviously at the point, for example, you have, imagine like Edward Snowden happens under this policy, people do value uncovering that the government has been wiretapping people's phones and listening in on conversations of the average person. I think there's something like individual jurors would be extraordinarily happy to know, and think it is obviously in the interest of the public, particularly just on the fact that in terms of convincing a majority of the jury and on a balance of probabilities, that seems extraordinarily likely. So I think they have to do much better work to prove why in the most likely and in our best case, that is actually in the outcomes particularly reasonable to occur. But even if you believe that in every single instance people get prosecuted on this side, that actually doesn't matter in this debate. Because we still create a metric for change. We still allow a barrier in the way of these people unjustly being sent into prison or forcing to leave and extradite themselves to Russia to prevent any kind of this information from getting out or continuing to happen. Any defense, and these people currently have none, is beneficial. That was only something that you actually meaningfully got on site affirmative. Final thing I'm going to briefly deal with in this speech is the right to privacy. I think that ultimately, the impact of this is just say, personal information is valuable and people can be harmed when it's released. Yes, which is why if you are going to be harmed caused by that, which is a violation of privacy and safety, there's a particularly high imperative to prove this for the public interest. And given the fact that obviously individuals can suffer when this information is likely particularly powerful, the best thing here might be to suggest that, even if you can get these people do get punished in prison, it's not good if the information gets leaked in the first place. Obviously that requires an individuals having to do that way up, and so presumably given people don't want to be sent to prison, it seems likely the instances where they actually do leak that information earlier can be good. For those reasons, proud to them.
No matter how Neg tries to spin it, proving that you didn't act and that it monumentally improved the achievement of public interest is always going to be very difficult. That is to say, a lot of people feel very strongly or passionate about a specific thing. You may be convinced 100% that the guy living down your street is a pedophile. However, that is not to say that giving people the ability to make that judgment about the future consequence of the act itself that they are likely to do is likely to be used in a good way. The problem with this legislation that Neg tries to talk about in this debate is basically a problem that comes down to trusting people to be able to make the way up before the action has happened. That is a fundamental divorce from reality, and that is why Neg wins. I'm going to do two things in this speech. First of all, I'm just going to preface the weighing of principles and why even if there are some cases in which they're likely to, for example, further public interest, why these are insufficient. Second of all, I'm going to talk about the worst tangible impacts on journalists, whistleblowers, and then later with police and vigilantes. So the first question about the weighing of principles. It's important to note that public interest can never be guaranteed, whilst a violation of privacy can. That is to say, even if you're someone who's convinced that there is a corporate malfeasance going on in this group of corporations, it is likely you will violate a number of those corporations before you end up on the one that is correct. That means you have guaranteed that violation of privacy, no matter whether or not that final benefit can be attained. That was incredibly important, because unlike the material we hear at second, it is not like murder, because it's not about the act itself, it's about the later consequence of the act. That is to say, it's about whether that murder would have caused more good in society later on, which is automatically a far harder thing to prove. That ultimately means that no matter if you believe the public interest will be achieved, sometimes you automatically know that violations of privacy will happen anyway, whether or not that's a violation of the organization itself or others attached to it, but also individuals whose privacy may be connected. For example, if it's a corporation that has a lot of information about where people live or people's healthcare, these are things that also violate a vast number of people on a far larger scale. We hear the claim from Affirmative that these boundaries are already murky. We already make a trade-off with public interest and privacy. However, obviously this exists to some extent. For example, video cameras can exist in public spaces, but you can't put a video camera in someone's house. That is the important distinction. Even if that video camera would capture a sexual assault, the fact that you're recording a person in the intimate aspects of their day-to-day and may or may not have caught that in the first place means automatically you're going to be behind under side Affirmative. We'd rather suggest that public interest is already murky, it is retrospective, and it is subjective. So for every good catch, there will be tenfold of ones who are inadequate. That was incredibly important and should be the way the rest of this debate is judged. So, moving on to the question of the adverse impacts. I'm first going to deal with this, the subset of people who are whistleblowers, who basically spends a lot of time in this debate about. Notably, whistleblowers are in a lot of cases not prosecuted based on these kind of violations of privacy, but rather treason and national security, which means that Julian Assange isn't in this debate because even if he wasn't at the moment, these organizations obviously have the incentive to try and prosecute these anyway, to the extent in which they can't do that, they're also going to become far less transparent in the first place, because obviously these abusive corporations, they don't want these violations to be found out in the first place. So, at the end of that, What then do we think is the alternative for a number of journalists, and why is it likely to fall side negative? We say that even if you are hacking for a good reason or a reason that might ultimately result in benefit, this might violate the information of individuals who deserve privacy and therefore may also suffer from their broader consequence. That is to say, if you violate like a gag order and somehow like information comes about an individual who was involved in a case more tangentially, that is a violation of their privacy there. Noting also that once again, magnified causes of backlash are likely to worsen the stakeholder in the first place. Moving on to the second subgroup, who is these police. Why do we think they're likely to be used really poorly? What they tell us is that, oh, you have decision-making calculus, you don't want to be found liable in the first place, so you're probably not going to do this. Once again, they did no work to prove that police on net are going to be these perfectly rational decision makers, and they will be able to guess whether in future that would likely be done well. A lot of police feel really strongly about a lot of things. You could be someone who really hated like terrorism and think that I'm going to make that way up, and it's going to be better for public interest. That I'm going to for example, trespass onto this person's property. I'm going to hack into this person's laptop. Obviously, that's an awful precedent to be setting in terms of police. Whether or not they're found to be guilty, found to not have reached that burden after the fact, obviously it opens up a lot of scope for changing the broader social narratives and ways these people are likely to view their work, because now there is literally legislation. The law says that you may be able to weigh out that public interest yourself and make that decision prior to the commission of any act you do. And second of all, we think the police already get a large belief by juries, so whenever they're talking about these things in the first place, it's unclear why these groups are going to be found out to be worse. We think opening this door up of defense, the defense of this public interest is insufficient, because even though you can have a precedent, you can have legislation, there's obviously a lot of wiggle room in a lot of these cases anyway. That is to say, weighing up privacy versus social impact, apart from this bizarre claim that it's very easy and very clear to see, obviously has a degree of ambiguity, and that means that these are the cases which is likely to be proved in a very meaningful way. So at the end of that, the police also are likely, in some cases, to have used this in quite a lazy way and to be able to protect themselves from acts that they know are going to be wrong. Whether or not a crime was committed is not the point. The point is that they chose to violate that person's privacy, and therefore, by numbers, that will always result in more harm. Moving on to the next group, which is basically the idea of vigilantism. We think this is an incredibly strong push that negative brings to you. That is to say that a lot of people, once again, as I flagged in my introduction, may be confident that something they're going to do is going to benefit society in the long term. Individuals can make decisions that may be bad for themselves and may be for society. So for example, if you decide to trespass on someone's land because you feel a commission of a crime is happening, if because of biases you feel with absolutely distrust someone's living next to you, and you think, there is no deterrence in this case because of the fact that even though you might be found guilty eventually, and maybe you don't satisfy these, at least you know that at least going into it, you have the perception that public interest is always going to get you out free, and therefore, in any case, you're likely to commit that harm is accrued whether or not that public interest was important. Moving on to the last question within this, which is just a quick note about NDAs. NDAs are not legally binding, and there are other ways to break them, therefore they fall out of the scope of this debate. Just a note about why that stakeholder is out. At the end of this speech, what do you know? You know that these cases of public interest versus privacy are uniquely damaging at the extent in which it becomes a full legal defense for people to use in court. That is because it puts an enormous amount of trust in people to be able to predict things which they might not know the outcomes of. And that necessarily means that you must default to voting side negative in this debate, because what we will know happens is you will have an extra video camera where it does not belong. You will have an extra hack of someone's laptop where maybe or maybe not there is some broader benefit attached to it. At the end of the day, that was guaranteed. The privacy harm was accrued. Affirmative could never win based on these tangential benefits they assume would occur as a result of public interest prior to the debate.
Side Affirmative's contention was never that privacy didn't matter. The contention was merely that privacy, like literally every other right, was something that we frequently traded off against other rights, and and other utilitarian benefits. I'll give you the examples. Trading privacy off against safety by having CCTV cameras in public, or trading privacy off against convenience when you engage in social media and give up all your metadata to Facebook. When privacy mattered more than other things was unclear was the subjective preference of different individuals. The claim side Affirmative made was because that was the case, the boundaries of what types of privacy were crucial that we protect and what types of privacy were okay to trade off against other more valuable rights or benefits was not inherently obvious, and therefore it was not easy to just produce legislation that protected all the good bits of privacy but allowed you to trade off all the less important bits of privacy. Which is exactly why the key question for this debate is, do you think you get better protection for privacy and better flexibility for individuals when you have politicians construct one piece of inflexible legislation that says these parts of privacy will always exist and always be protected and can never be traded off, and these parts are free game, you can do whatever you want? Or was it better to allow politicians to write a broad privacy protection and then have courts make individual carve-outs and carve-ins for the areas of privacy that are determined to be important and those where it's acceptable to make trade-offs? That was the contention of side Affirmative, that courts were the best placed actor to engage in a series of trade-offs to determine when privacy mattered and when it made sense to trade off against it. They've yet to respond to the crux of this argument. First thing I want to do is just respond to their claim that this will be easily abused, and so even if you believe that there might be certain instances where it makes sense to make these trade-offs, people will just be so overly keen to go and violate other people's privacy that you'll get a bunch of bad privacy violations occurring instead. This doesn't make sense for a number of reasons. The first thing is just that it relies on people deeply misunderstanding how the law works and just assuming that the thing they want to do happens to be legal because of this law. To the extent that people are that misguided, they'll probably be misguided under the status quo and just commit a different crime. But secondly, we point out the average person is risk averse and doesn't just go doing something that may be legal because maybe I could prove it in court. Thirdly, because the consequences are likely to be pretty bad, like maybe they go to prison or something on their side, you probably wouldn't just rush into this pell-mell. And fourthly, because obviously, even if you do succeed at court, it's an unpleasant process, you probably don't want to have to go through the process of proving that you're innocent in court when you could just not do that in the first place. And lastly, we point out that you probably just look at the precedent of where other people have been able to demonstrate public interest has succeeded and be like, oh, well, a whistleblower was able to demonstrate that demonstrating the government engaged in massive malfeasance was a sufficient reason to violate privacy. Me, snooping on my neighbor probably doesn't sound very similar to that instance. Maybe I won't go and do that. Notably, no one has won a public interest case by just trying to suspect if they're, trying to work out if their neighbor is a pedophile or not. That probably seems like something the court would not engage in. But lastly, if you really believe that these individuals are just so convinced that this thing is urgent and in the public interest and needs to be done, that sounds like something they'll do in the status quo even without this protection. They really believe their neighbor is a pedophile and it's the most urgent thing to prove that they are. They would just rush in on either side. This doesn't explain why things would in fact occur in the way that they do. So the conclusion of this first argument is to suggest that people are likely to be very circumspect about when they use this. They're likely to think very carefully about doing this. And that explains why the use cases where people actually are engaging with this, it's probably just not average people being like, oh, I bet I could generate some public interest by violating people's privacy. It's probably people like whistleblowers who take very serious consideration after discovering some information about whether or not it's something they think needs to be revealed. It's people like journalists who obviously have the capacity to consult lawyers and legal teams about whether or not a public interest case could be made prior to commencing in a particular investigation. It's people in these capacities where they're very likely to know that what they're investigating is in the public interest, but they're very likely to be able to generate very large benefits on our side, which is why all the things we tell you are insufficiently responded to. We get one response as to why these cases wouldn't hold up, which is just to say, well, whistleblowers, etc. would always lose because they'd just be charged under some other sort of act like treason or something. We would suggest we'd be very, often the way that they're charged is just they'll accuse a unauthorized, they access to computer device in an unauthorized fashion. They stole information they were not allowed to have in those particular instances. Treason would obviously require you to hand the information over to a hostile foreign power, which we think is a very hard case to make, far more likely to make a far easier argument. The second case is just to say that the government is so powerful, you'd never ever win a case against them. Well, one, that's just a reason we should throw the legal system in the bin and move on. But secondly, more importantly, it's not just the case that if you have money, you immediately win your court case. You do still have to make arguments. You do still have to convince juries, which are reasonable people, people probably don't like when the government engages in illegal actions or corporate malfeasance, and probably are very sympathetic to things like revelations of information that mean that they're able to hold those governments far more accountable. Which explains why we're able to get a huge set of benefits in this debate. Things like uncovering corruption, things like massive whistleblowers, things like violating NDAs where they're abused by people to cover up their own malfeasance, all of which is unlocked on our side and they insufficiently respond to. The second claim of abuse is just to say that cops will use this as a way to sort of get around protections like requirements for warrants, etc. First thing we'd suggest is this sounds a bit like the status quo where they already do those things, and notably because they have things like qualified immunity, and because of things like national security legislation, it's often impossible to hold them accountable anyway. It's unclear why this law has any effect in tipping the balance at all. But to the extent that you believe that cops are, punished in the status quo, we would explain that they very likely are to still be punished. They provide no reasoning as to why juries would be favorable to them when they're violating people's rights, storming into people's houses. That is exactly the kind of thing that people really hate, and Dan provides you great analysis as to why this is likely to be the case. The last thing I want to do then is just emphasize why it is that courts will do a good job in determining where these boundaries are drawn. And note, they haven't given a single response to the 5 reasons we give you down the bench as to why courts are really good at determining when public interest does in fact outweigh privacy, which is the key explanation we give you as to why this is so useful. Because lawyers and politicians are incredibly bad at drafting laws that take into account all the variety of nuances where, for example, it is important that we violate privacy for a bigger benefit, like whistleblowers. They're very bad at determining the individual cases where the privacy might need to be protected. And so they run the risk on their side of drafting legislation that is inadequate and doesn't protect people's privacy when they need it, or in other instances, drawing overly broad legislation that prevents you from engaging in things like whistleblowing where that is needed. What are the reasons we give you as to why courts will do this well? Firstly, judges are deeply experienced in the law and very good at engaging in trade-offs. We point out that the Evidence Act already requires a series of trade-offs that are very similar to this. For example, if evidence could be prejudicial to a party, the requirement is that they prove to the judge that the probative value is outweighed by the prejudicial value of the evidence. Very similar to demonstrating that the public interest outweighs the privacy violation. Seems like exactly the kind of thing judges would be good at. Secondly, because this is a subjective question of where do we draw the boundaries of one right against another right, it makes sense that you should ask a jury, which is just an amalgam of society, where they think that boundary should be drawn. And they're far more likely to be able to give an answer that is representative of society's opinion. The only legitimate body can determine questions of where rights should be drawn because there's no correct moral answer. It's not like this team just seems to think it's very obvious where privacy matters and where it doesn't. No, like different people have different opinions. You need to be able to survey society to determine where that's the case. But thirdly, we have an adversarial system. The prosecution will argue why it wasn't in the public interest. The defense will argue why it is. The judge and jury will be incredibly well informed, will have access to the best perspectives on either side, and will be able to decide from there. But fourthly, we explained that there'd be precedent already built up, and courts are required to follow that precedent. So you already have established cases on the kinds of carve-outs where, for like whistleblower protections, that would just allow those things to occur easily. But at the same time, you'd have evidence saying like spying on your neighbor, not in fact in the public interest. You can't do that. There wouldn't need to be serious consideration of those issues. Finally, we explained that judges are very likely to take this matter particularly seriously as are juries. Look, at the end of this debate, side and affirmative recognized that it was unclear where privacy was important and where it wasn't. It was best to allow individual case-by-case determinations, not the blanket, inflexible policy this team forces on you.